Good evening, everybody. It's Wednesday night, so that means I'm welcoming you to another episode of Calenda, Attorney at Law, on the Coalition Radio Network. I'm your host, Calenda, an attorney at the law firm of Inman and Torgy here in Coventry, Rhode Island. And as usual, I'll be hosting tonight's show. And most importantly, I will be putting the law above politics. We're continuing this series where we touch on various legal topics here in Rhode Island and nationally. And tonight we're going to discuss some developments in the federal lawsuit by healthcare workers challenging Rhode Island's Department of Health regulations that don't allow anyone employed by a healthcare facility an exemption from the COVID-19 vaccination on the religious grounds. And I'm also going to touch upon another issue of the abuse of the bail system by the Rhode Island Attorney General's office. That's been a rampant problem here in our criminal courts. Joining me to discuss these topics tonight is frequent guest and Coalition Radio Network station management, Pat Ford. Pat, as always, thank you for joining me tonight. And boy, do I have a few things to get off my chest tonight.
I've got this delicious new Dunkin' Donuts caramel apple cider cold. The voice is shot from bellowing questions. If you remember back in the day when, but possibly before your time, when Tricky Dick, Richard Nixon would, and Ronald Reagan for that matter, and actually Jimmy Carter, and actually every president imaginable, used the whirring of the Marine One helicopter so that they could put their hands to their ears and say, "What? I don't hear you." And that's what I get to do on a daily basis. So I think I'm going to kick back. It appears, based on our brief pre-show conversation, that you might be a bit peeved, if you will, a bit verklempt, a little taxed, perhaps a tad annoyed, mixed in with a helping dose of frustration, anger, and, well, outright hostility at the political powers to be. I think I summed it up fairly neatly.
I'd say you did. I'd say you hit the topic right on right on the nail right on the head.
Well, if I can quote one of the great film noirs of our time, harkens back to a movement in American cinema that I refer to as the Saturday Night Live era, and of course I'm talking about perhaps one of the most intense character developments mixed in with a healthy dose of originalist American music. And of course, by that I mean the movie The Blues Brothers. If I could paraphrase one of the great lines in the movies, unnecessary force in the apprehension of our legal system in Rhode Island is, in fact, fully authorized. And I have checked with station management as to appropriate boundaries on the conversation, and we are about to enter a safe word-free, no boundaries, no limits conversation. So, Attorney Calenda, take it away.
Well, Pat, there's been it's been a little frustrating. Let's not just say this week. Let's just say for the last several months, perhaps maybe the last 18 months, as we've been flattening this curve, so to speak. That I've been there hasn't a day has gone by that we haven't talked about some variant of COVID or some response to the COVID pandemic that the Rhode Island state government can't seem to get out of its own way to get right. And today just kind of pushed me over an edge, and that I just didn't think I'd get to because as many of you know, I was away on a nice little much needed vacation over the last 10 days. And I come back and knowing that the healthcare workers here in Rhode Island had filed a lawsuit in the U.S. District Court here in the District of Rhode Island, challenging the Department of Health state's regulations that basically forbid them from seeking an exemption to the state vaccine mandate for healthcare workers. They're saying that it violates Title VII of the U.S. Civil Rights Act of 1964 because it does not grant them the ability to request those religious exemptions, and the Department of Health is not allowing them. I was reading some of the arguments that were being made in federal court today in front of Judge Mary McElroy, who many of you may know was the former chief public defender for the state of Rhode Island during her tenure as a chief public defender for the state of Rhode Island, and as a former assistant federal public defender. She stood up for the constitutional rights of many people accused of criminal acts and she's the one overseeing this federal lawsuit. And Attorney Joe Larissa, who I don't know, who filed on behalf of the 4 anonymous plaintiffs. They filed this anonymously because they are so fearful of retribution that they are doing this under pseudonyms. That Joe Larissa, who has filed this, has argued that Rhode Island's refusal to recognize sincerely held religious belief objections to the vaccine mandate violate Title VII of the Civil Rights Act of 1964. And right now, that seems to be the case, because if you look at people who are working in any sort of healthcare system, and I field these calls probably 10 to 20 a day, Pat. 10 to 20 a day, I get calls from people working in any variety of healthcare systems, calling me, asking me, some in tears, asking me what can they do legally to fight back against this, because they've been nurses, doctors, some sort of healthcare provider for years, and they are about to be terminated on October 1st, or they have their license revoked by the Department of Health because they have concerns. These are medical professionals, by the way. They have concerns about the safetiness of the vaccines. These are not cranks who are against all vaccines. These are not people who are just anti-vaxxers for the sake of being anti-vaxxers. These are people who are trained medical professionals, and they have legitimate questions about perhaps maybe this is not in my best interest. And they have filed suit to try to seek an injunction, a restraining order for those who are not versed in legalese, to try to prevent the state from taking away their livelihoods. And the Attorney General for the state of Rhode Island has entered on behalf of the governor as his attorney, and the Department of Health as their attorney, to defend the mandates. He's sent one of his assistant attorney generals in to make the following argument as to what the court should expect from the state and employers, and what employers should do in this situation. So, an assistant attorney general on behalf of Peter Nerona, our current attorney general, self-proclaimed activist attorney general, indicates that there is nothing in this mandate that prevents employers from considering exemptions based on religious beliefs as required by Title VII of the 1964 Civil Rights Act. In fact, according to the Providence Journal article that I'm reading here, that's precisely what they should be doing, and the state will not get involved in that. So basically, he's saying that these healthcare workers should go to their employees, should request a religious exemption from their employers, and they can grant those exemptions. However, in the same breath, which is absolutely breathtaking to me, in the same breath, the Assistant Attorney General, on behalf of Peter Nerona, the Attorney General, says the Department of Health, however, will not allow anyone who is not vaccinated, whether or not they have a legitimate exemption or not, into any healthcare facility. So doesn't that kind of end the discussion between the employee and the employer? So yeah, sure, have that discussion. You're supposed to have that discussion, employee, employer, and you can grant them their exemptions. However, we as a Department of Health in the state of Rhode Island are not going to let you into your place of business if you get one of those exemptions. How does that sound to you, Pat? What kind of position does that put somebody in? And what kind of argument is that got no pushback from Judge McElroy?
One of the mottos of the Coalition Radio Network is, in the halls of justice, justice is in fact often found in the halls. That's what it sounds like. There was a song in the 70s called Rubber Band Man, and the contortions that our legal system is going through in order to simultaneously uphold body autonomy on certain issues, as they should, and at the same time wrest control of one's body from the individual, is an astonishing act to watch in slow motion. It is, in fact, a legal driver's ed film, except we are all in the passenger seat, unable to really accomplish any intervention, and yet somehow unable to avert our gaze. They're working, these are solutions-based outcomes. They are ultimately twisting the legal system in order to support their desired outcome. And yet, none of the quote-unquote establishment is willing to do anything to support the fundamental civil rights of the individual.
None
Yikes.
whatsoever. It is an astonishing. I'm an attorney, and I'll tell you, attorneys are an odd bunch. That's to put it mildly. But I'm astonished. I'm astonished at the lack of interest from the ACLU, the organizations that purportedly are there to protect people's civil rights, purportedly to protect you from overreach of the government, that have so little interest in even questioning the conventional wisdom of our so-called professionals, our elected officials, who are apparently now all experts in virology, medical, public health, all these sorts of things. The lawyers, I'd say about 90 to 95% of them look the other way and say, "Oh no, this is all good. This is what we need to be doing." It's like they're all falling in line. And when lawyers like me speak out, or Mr. Larissa, who's filed the suit in the U.S. District Court, speak out, we get looked at like we're the rabble rousers. We're the people who are putting people's lives in jeopardy, when we have plenty of science that have been peer reviewed, that have been actually put out there by the CDC, put out there by independent medical organizations, medical journals, universities, medical schools, that show that yes, the vaccine is effective in many ways, and for many people it makes a lot of sense. But in many cases, people who are vaccinated are probably not going to experience this kind of symptoms that somebody who gets a severe infection of COVID is going to experience. But the people who are vaccinated, it's been shown by these studies, are carrying large amounts of this viral load that's in their system, and they may not even know it because they're asymptomatic. They don't have the outward symptoms to make them feel like they have anything going on with them, and they're actually the ones spreading this more so than the unvaccinated individuals, although those people are more likely to be infected with a severe version of the disease. So we are, I mean, I can't even tell you how many times the guidance has changed on this, and people will respond and say, well, we're learning more and more about the virus, we're learning more and more about the treatment of that. But it has not evolved to the point where everything we knew about it from the beginning is no longer in effect. And it's just the goalposts have moved at least 5 to 6 football field lengths, and it just keeps getting worse and worse. And it's just, and when I read arguments like what I read from the Attorney General's office, who's basically acting as legal cover to the governor and legal cover to the director of the Department of Health, for issuing emergency regulations that are not going through any sort of legislative process, not going through any sort of legislative approval. These are all acting under the so-called declaration of emergency, from going all the way back to Governor Raimondo and now Governor McKee. It's unbelievable what we, the people, and what lawyers, and what our elected officials and appointed officials in this state, and not only this state, but across the country, have been willing to put up with. It's astonishing.
Is there any appeal? Well, take us back, if you will. What's happened the last day or two in terms of, there's been a couple of court cases. I know you were out of town. You just got back into town. But kind of walk us through the steps and what's actually happened. Because a lot of folks, again, we're all experts, or we're not experts. We just play them on the radio.
So in the federal lawsuit that I was referring to, today was a motion for a preliminary injunction on behalf of the healthcare workers, seeking to restrain and enjoin the state from basically taking away their jobs and not offering religious exemptions for the vaccine. Judge McElroy heard arguments today. She did not rule, but a preliminary injunction would be, if she were to grant that, that would be an order preventing the state from enforcing that mandate without offering religious exemptions while the case plays out on its merits. Now, a preliminary injunction, if that were to be granted or denied, can be immediately appealed to the Circuit Court of Appeals. In this case, it would go to the First Circuit in the federal system. And that's the one, that's a court based in Boston, usually goes to a panel of 3 judges. They will decide whether or not the district court judge acted appropriately and in accordance with the law. And if that doesn't work, that could be petitioned to the United States Supreme Court if they decide to take it on a petition for writ of certiorari. That's one area that's gone on. There was another case that was heard in state court, in the state superior court, where the firefighters union attempted to file for an injunction in state court because now, based on these new emergency regulations from the Department of Health, based on the mandate from Governor McKee, they're saying that their licenses, their EMT licenses, have now been changed in the sense that they can no longer be employed by fire departments because they will lose their EMT license because the emergency regulations now require anyone with an EMT license to have the COVID vaccine. So again, you're in a situation where you have no option to opt out and you lose your job if you do so. And they were saying that violates the right to collectively bargain because most of these firefighters are unionized and they have collective bargaining agreements. And that would take away their right to collectively bargain because they're already working under collective bargaining agreements. And this would be something that would be normally subject to collective bargaining. Judge Darrigan of the Rhode Island Superior Court rejected that argument and denied the preliminary injunction in that case.
Oh, did we lose him? Oh, hold on a second, buddy. Oh, I can't hear.
Oh, well, I was just saying that they had that in the state court, Judge Darrigan denied the firefighters' injunction, saying that she did not find it to be a situation where there was any new requirement of employment. Which to me, I mean, with all due respect to Judge Darrigan, who I like very much as a person, she has a great temperament, and she does give a lot of thought to her decisions. I just don't see how that's a realistic conclusion you can draw because you have a collective bargaining agreement which lays out the criteria for what for people who are firefighters, what they need to have in order to become firefighters. And these people are already firefighters with EMT licenses. And most of them are EMT cardiac licenses. And to say that this does not impose a change upon their employment conditions, that takes away their ability to collectively bargain with the firefighters, with the employers, the fire stations. To me, that makes no sense. I don't know where you could come up with a factual basis for that conclusion.
So, as a layman, it just, again, the legal gymnastics that appear to be taking place here are astonishing. Is there anywhere the ordinary individual can turn at this point? Are there grounds for appeal? Are we talking, again, as we've reflected on it so many times, that the cost basis to appeal is so onerous that it's not possible for mere mortals? And at this point, do we have a judicial system that's thoroughly rigged to the whims of the elite?
Well, I'll go to your question about the costs and the availability of an appeal first. I mean, the availability is always there, but appeals take sometimes years. And in Rhode Island, at least on the state side, to appeal a decision of the Superior Court to the Supreme Court, I mean, that, unless it's done on an emergency basis, which is exceedingly rare, that could take years. And there's not a whole lot of people who practice, whole lot of attorneys who practice in the Rhode Island Supreme Court because it's a completely different type of practice. It's not like you go into the court, you file a lawsuit, you go through discovery, you go before a jury or a judge, and they issue a decision. I mean, there's a lot more writing involved. It's a lot more precise. It's a lot different style of argument, if there is an argument, and it's all discretionary. You don't have an automatic right to an appeal necessarily in every case. So, and the people who take these cases are likely to charge, exorbitant amounts of money. So unless you're independently wealthy or you have some sort of crowdfunding to support your legal fees, or you get a lawyer who's able to has the resources to do these things on a very scaled down basis or a pro bono basis, the likelihood of us, as you say, mere mortals, being able to go through the entire process without emptying our bank accounts on the slim chance that we may get a favorable ruling, in many people's opinions, is just not a realistic option. I mean, as a lawyer, under the rules of professional responsibility, I can't sit here and say we have a rigged judicial system. I would be impugning the integrity of every judge on the bench, which I'm certainly not going to do. I disagree with the ruling of Judge Darrigan, but I mean, there's no lawyer on earth who's not going to disagree with any particular judge's decision on any particular day. And I disagree so far with the way I see Judge McElroy leaning towards in the federal court. But I have not seen, with the exception of the U.S. District Court in the Northern, or I believe it was the Western District in New York, that did issue a temporary restraining order on this very same issue, the lack of religious exemptions in the healthcare vaccine mandate in the state of New York. Originally, the district court there did issue a temporary restraining order preventing the state of New York from enforcing that mandate. In a very unusual move, that was immediately on an emergency basis appealed to the Second Circuit Court of Appeals on the federal system, and they dissolved that injunction without even hearing arguments.
So we're screwed.
I would say so. I would say so. As far as the legal basis is concerned, we're screwed. This has become a political issue. And I remind every single person, and this may sound like a partisan statement, but it's really not, because it could apply to any party that has complete control of any state or any lever of government that makes all the decisions. But I remind everybody who calls my office and feels helpless about the situation that they may find themselves in, that they have to choose between their livelihood or their conscience or their religion or their medical concerns, that remember who made these laws, remember who put these mandates in place, and remember who's defending them and suing you and taking away your livelihood for trying to fight back. In this state, we all know who that is. That's the Democrat Party. They hold the lever of power on every single state office in this state, and they control the General Assembly by supermajorities. All the appointees from the state officers are made by those people, so it is very likely that those political appointees share the same political views of those people who appointed them. So I tell everybody, your power is at the ballot box. Your power is to remove the people from power who are not listening to you, who are saying, we know better than you. We know better about your body than you. We know what's good for the rest of you, even if you may have a specialty in this background. We're the governor. We're the director of the Department of Health. We're the lieutenant governor. We're the attorney general. We know better than you. Remember that next year when you go to the ballot box and cast your vote, because that right now looks to be the only way that you are going to overturn these mandates, because they have absolutely no incentive to do that right now because there's nobody holding them accountable.
Let's also focus for a second, if you will, on the specter of the people's lawyer suing the people. How does that work?
Well, The Attorney General has kind of a dual role. So sure, the Attorney General is the state's lawyer, as part of his job. He is there to defend the state from lawsuits. And as you know, Pat, anybody can sue the state and does sue the state for a variety of reasons, some of which are legitimate, some of which are vexatious. But the Attorney General, part of his job is to defend state officials. However, that is not the only part of the Attorney General's job. The Attorney General is also the people of the state of Rhode Island's lawyer on issues to make sure that the law is being enforced. Now, the Attorney General may not like that law, but if that's a law that he has no way to say that is illegal or otherwise violates somebody's rights or violates some sort of provision of some other state law or federal law, that's one that he is bound to enforce. And right now, the Attorney General is rubber stamping everything the governor and the Department of Health is doing. He is the one when these people filed suit in federal court against the Department of Health and against the governor, the Attorney General is the one in court defending them and fighting to maintain these mandates. That, to me, given the situation that we're in, where we have a legitimate Title VII question under federal law, and we have a legitimate anti-discrimination question under state law, whether or not these mandates comply with those provisions. Attorney General Noronha should not be sitting there rubber stamping these things. He needs to be the independent constitutional officer that he was elected to be. He does not report to the governor. He does not report to the director of the Department of Health. He does not report to any other person in the state of Rhode Island. He is independently elected and he has authorities issued to him under the Constitution of the state of Rhode Island, which makes him an independent chief law enforcement officer for the state. And the fact that he is chosen to be the rubber stamp for the governor has proven his point, and he was right about this, that he is going to be the activist attorney general, and he's going to push an agenda that is politically driven as opposed to one based on the law and facts.
It's essentially, if I understand your point, every single Rhode Islander that's got a connection to this case has abdicated their fundamental responsibilities to the citizenry. Is that an overstatement?
Well, every single elected official, is that what you're saying? Has abdicated their responsibility?
Everybody. I'm talking about from the guys in the robes to the guys at Halitosis Hall, to the health department, to the appointed bureaucracy, to the professional staff. Everyone is just hell-bent on control.
I would say that is absolutely correct. I certainly, what I've seen so far in the judicial system, I have not seen a judge who has considered this issue be willing to actually dive into the actual law, to look at the actual issues, as opposed to just accepting the representations of the Attorney General's office, which the quotes I read for you earlier in the show are just absolutely specious arguments. To say that you can have a religious exemption from your employer, but you're not going to be allowed into the building even if you get that religious exemption, because the state's not going to allow you into that building because they're going to revoke your license. To the fact that he actually said that, the Attorney General's office actually said that in court, should have received a swift rebuke from the judge overseeing that case. And the fact that they didn't get one tells me we have people who are not willing to look at the civil rights of the people being affected here, who are not willing to seriously look at it. They are hell-bent on control, hell-bent on making sure that people are following the directives of those who are in charge. And if you don't, you are not going to be allowed to be a meaningful part of society.
Other than that, Mrs. Lincoln, how was the play?
I mean, that's not an overstatement. That's not an overstatement. Pat.
No, what's equally amazing, you and I have been doing the show together on and off for a few months. You've got some outstanding legal talent on the show, and then I fill in from time to time. If, for example, you've had a challenging week in court, or it's the news cycle demands it, as it does tonight. Usually, there's one side of the room which is full of inflamed tensions. And a great deal of agita, if you will. That's normally me. To see you this, again, you're the adult in the room. You'll always be the adult in the room between the two of us. But to see you as thoroughly outraged as you are right now, having gotten to know you over the last year or so, is, again, and we're going to use the word astonishing a lot tonight, obviously. And I'm usually the master of the hype and the hyperbole. But wow. And folks need to reflect on something. Lawyers, much like doctors and certain what I'll call the gilded professions, accountants, and I mean that as a compliment, typically refrain from a lot of conversation about the rulings and the behaviors of others, unless it's really warranted. To see someone like yourself, who is very conservative in his speech, and again, that's a compliment, just inflamed by this speaks to the seriousness of it. And how dangerous of a precedent is this? And, where do we go from here?
Pat, I try to be restrained because I found in my 15 years of practice that going into court and just throwing a temper tantrum doesn't get you very far. And not that I'm throwing a temper tantrum here tonight, but at some point when when logic ceases to exist, when common sense ceases to exist, even in a hallowed place, I'd still like to think that the courtrooms are a hallowed place where you can have your day in court and have your arguments fairly heard and decided by a jury or a judge. When I stop seeing that happen and I see the system corrupted, and I'm not seeing it so much corrupted by the judges, more so, I'm seeing it more so corrupted by some of the attorneys, particularly the Office of the Attorney General. And it's not just in the COVID realm as we're talking about here, but in the criminal justice realm, which as you know, I do a lot of work in there. It's something that at some point, as a person who likes to think that a well-reasoned argument, a well-researched argument, and a well-articulated argument is going to win the day over one where it's really just more of emotion and screaming. It's disappointing. It's exceptionally disappointing. It's the reason I'm running for Attorney General, is because the position that Peter Neronha currently holds has the authority to stop this. Or at least the authority to attempt to stop it. And it comes with a lot more oomph, if you know what I mean, if you have the Attorney General of the state going to court and saying, hold on a minute, Governor McKee, hold on a minute, Director Alexander Scott, hold on a minute. I'm not quite sure you're on solid legal footing here. And I'm not going to represent you because of that. I'm going to make you use your own legal counsel. And they have plenty of legal counsel within both the governor's office and the Department of Health who are capable of litigating this. But the fact that the Attorney General is in there saying, oh, no, this is all good, and everybody's doing this is going to lose their jobs. And I have no problem with that, despite the fact that I go on TV all the time with Gene Valcenti and whoever else wants to interview me and let me say all my flowery, nice guy language. That's not really what he's doing. What he says and what he does are two different things. And that applies to the COVID realm and these mandates realm. And that applies to all his policies and the way he runs that office in the criminal justice system, which we've seen recently. And although I was on vacation, I did get to see the backslapping and the handshaking all over the defelonization of certain amounts of drugs, which I don't necessarily have a problem with, but I can tell you that although Attorney General Noronha spoke of the fact that he played an instrumental role in getting that legislation passed, I can tell you that in practice, his office is not nearly as forgiving on these indiscretions of individuals in court as Mr. Noronha claims they are.
Oh my. Well, we want to talk about bail tonight as well, right?
Well, that's one of the other issues that's really got me fired up, because most of my practice is in criminal defense, and in recent years there have been serious attempts by I think it was the Rhode Island Supreme Court, justices of the Superior Court and the District Court, to try to revamp the bail system in Rhode Island, to make it more likely that those who are accused of criminal offenses before they're convicted are entitled to bail. Are entitled to not only just bail, the presumption is you're entitled to your personal recognizance, which means that when you are arraigned of a criminal offense, you do not have to post any money, and you just promise to appear, keep the peace, and be of good behavior. There are certain offenses under Rhode Island law where you are able to be denied bail in its entirety at your arraignment, because that's what state law allows. Now, state law allows it, but it doesn't mandate it. Now, what has to happen in order for you to be held without bail on one of those charges is that the state of Rhode Island, through the Attorney General or the police department, must object to the setting of bail at your arraignment. And if they object to the setting of bail, the judge has to hold you without bail for at least 2 weeks before you get a bail hearing. And at that point, the state of Rhode Island, through the Attorney General, has to put on evidence to satisfy the judge that there's a likelihood that you'll be convicted after trial. Now, I've been in court for 15 years practicing criminal law in some sense, both as a prosecutor and a defense attorney. In the last almost 4 years as a defense attorney, I've been in courtrooms where I've been speaking to, we have conferencing a case where I have one of these cases where somebody's charged with an offense that they're not necessarily entitled to bail, but they can get it if the state doesn't object to it. Not all of them are violent crimes. Some of these crimes are drug offenses, which I believe were a big hot topic recently. And even certain offenses are just possession of certain quantities of drugs can get you held without bail. But I've been in court on several of these cases where the evidence itself may be a lot less strong than the state would like to see it, or the person has got no record, or there's other circumstances which would be reasonable to allow this person bail. And the prosecutor is actually saying, a prosecutor working for the Attorney General is actually saying in open court to the judge, I realize that this is a case where bail is probably appropriate, but I'm not allowed to set it because I'm being told by my superiors in the Attorney General's office that I have to go to a bail hearing and I have to object to bail. So that means that person, even though that particular prosecutor in that person's judgment is probably entitled to bail, that means that the person who's charged with the offense is going to sit at the ACI until a bail hearing can be scheduled. Despite the fact that the prosecutor doesn't believe that that's the right call, he's being told what to do by the administration of Peter Noronha. And that, to me, is a violation of professional ethics. It's a violation of the role of the Attorney General. It's a violation of the rules of the road, which are posted in almost every office in the Attorney General's office. And it doesn't do justice to anybody. And to hear a prosecutor admit that to a judge should also get a swift and brutal rebuke from that judge. And 9 times out of 10, it doesn't.
Wow. And you worried about not being able to fill up an hour. Wow.
Yeah, it's incredible, Pat. And I say this, and I bring this up because I'm sure we're all aware of the case that was down in South Kingstown, where we had 4 black males who were accused of sexually assaulting a white female. And it was a case where the evidence was at best questionable at the time when the arraignment happened, or the bail hearing happened in the Superior Court. in front of what I consider one of the fairest judges in the state. And there was a lot of community outcry over the lack of evidence that was in that case. And just having practiced, I practiced a great deal in Wakefield area, and just happened to have him be there during the time where these cases were being conferenced uh, in front of the judge of the Superior Court down there, knowing that the judge was kind of leaning towards setting bail before a hearing was going, but the prosecutor not being able to do so uh, based upon the fact that uh, the order had come down from the administration. Uh, that was an outrageous circumstance where those individuals had to sit in the ACI until a hearing happened, which it did. A hearing happened several weeks later. The judge not only found that the evidence was woefully insufficient, the judge set personal recognizance on charges of first-degree sexual assault, which carry, mind you, a penalty of up to life in prison if they were to be convicted. Uh, and then after that, the AG quietly dismissed the charges against all four of the defendants and put the line prosecutor's name on the dismissal instead of Peter Nerona coming out and explaining why we're not even going to present this case to a grand jury after we objected to the setting of bail at the initial arraignment. It was an absolutely outrageous set of circumstances, which the community had every right to be upset over. And I think, and I hate to throw this out there because I think it's overused in a lot of settings, but I think a lot of it had, so unfortunately, some racial undertones to it.
Wow. Mm. Again, the criminal justice system being used as a weapon against individuals. Has that happened? Have we effectively weaponized what passes for a judicial and a criminal justice system here in Rhode Island?
It happens a lot. It happens more frequently than you think, Pat. It happens a lot of times, and in the people who practice in family court can tell you this, in the context of divorce proceedings or domestic proceedings in the family court, you've got then litigants who decide to use the criminal justice system to try to get some leverage in their family court case, whether it's for money or custody of children or whatever it is. That's been going on for years. But now we've got an attorney general who's weaponizing the criminal justice system against law-abiding gun owners, against people who have legitimate questions against quarantine and vaccine mandates. You have now, I'm getting cases, excuse me, of for people who are federally licensed firearm dealers who are getting threatening letters from the attorney general's office because the new laws that have been passed, that there maybe was a technicality that was overlooked in these new laws, and they're threatening them with criminal prosecution if it continues. I mean, this is an absolutely outrageous situation for the chief law enforcement officer, who really should be an apolitical actor, to be getting involved in. And this is why I'm using the term law above politics in my campaign to be the attorney general, because it is far too important to have it is far too important a role to have a person like Peter Nerona in there acting as a political actor. As the Attorney General of the state of Rhode Island, it is far too important to make sure that people's rights are protected and get the politicians out of that office.
Excellent. Excellent analysis, sir. Well, we may need to have a couple of emergency interventions here over the next few days because, Friday is for folks who are employed in the medical industry who, for a number of reasons, have made a personal decision. Yikes.
Yikes.
This is going to be a hellish couple of days.
Yikes is it. I had a woman crying on the phone to me today, Pat, literally sobbing her heart out. A pregnant woman who has legitimate concerns about there's lack of research as to what this vaccine may or may not do to someone who's actively pregnant, crying her eyes out because she cannot be granted a medical exemption nor a religious exemption under current state guidelines, and she's going to lose her job come Friday. And all I could do was try to console her the best I could, because the lawsuit's been filed. We're waiting to see what the federal court's going to say. But it breaks my heart as somebody who cares about people's civil liberties and constitutional rights to have to take those phone calls and then have to hang up and look at myself and think to myself, is there something I can do to help? Is there anything else I can do to help? And the only thing I can do to help at this point, in this situation, barring some extraordinary ruling by a court, is to make myself a candidate for the Attorney General's office, which I am, and try to make sure that this doesn't happen in the future, because this has wide-ranging implications.
Well, take us home. How can folks reach out to you? How can folks find you on the web? We'll certainly be sharing this conversation and some of the conversations we're going to be having in the coming days. In which, and by the way, if you're listening to the show, we'd ask you just to take a moment if you could like the Facebook or follow us on the YouTube or on Twitter. You can find on our heading page and the facebook.com/Coalition Radio. You can find a link, if you will, which will give you all our social media, including our re-emerging Instagram page. But how can folks find you, Chaz Calenda, both in terms of your practice as well as your politics?
So as far as my practice, as I mentioned, I'm a lawyer at the law firm of Inman and Torgy. That's at 1500 Nooseneck Hill Road in Coventry. You can reach me at 401-823-9200. That's for my legal services. You can also feel free to call me. We give free consultations on most issues that we do over there. As far as my political campaign to be your next Attorney General here in Rhode Island, you can go to my website at chas, CHAS, 4ag.com. You can also find me on Facebook, Twitter, Instagram. And I'd just also like to, Pat, thank everybody who turned out 2 weeks ago at Brood Awakenings in Providence for one of my political events. It was a great success. I was able to meet a lot of people that I wasn't able to personally meet prior to that date, contact a lot of people, and raise funds for my campaign. It was a tremendous success by all metrics, and I just can't thank the people enough who showed me support, whether it was financial, verbal, or promising me their vote. It was a tremendous success, and I hope to have many more of those going forward. I know we're going to have several more in the upcoming months, as it's now full-time campaign season. And I would encourage any of you who are interested to reach out to me in that capacity.
Super. All right, buddy. Have a great night.
Pat, thank you as always, and thank you all for watching another episode of Chaz Calenda, Attorney at Law, and we'll see you next Wednesday. Thanks again, and everybody, good night.